Welcome everyone on behalf of Monash Law School and the Centre for Commercial Law and Regulatory Studies at Monash Law School. Just a couple of housekeeping matters. We're delighted to have Monash University's Better Governance and Policy Institute involved in this roundtable, and the Institute has asked me to let you know that it's hosting a live Twitter feed throughout this webinar, and you can be part of that conversation if you would like to be by following @MonashPolicy and using the hashtag @MonashPolicyMatters. We'll try and get that up into the Q&A box for you as we go along. Now, just housekeeping, we welcome questions from the audience. You will have to type your questions in the Q&A box, and I'll try to cover them as we go through for today's seminar. If you could type them and also type yourself and affiliation. So just identify yourself and your affiliation. I'd like to introduce the speakers now because it's a fabulous array of speakers. We're still waiting for him to get online. We're hoping he manages. A little glitch at his end. Noel Hutley, Senior Counsel. Noel is a Senior Barrister in Sydney, specialising in commercial law, and he's a former president of the New South Wales Bar Association and the Australian Bar Association. Our other panellists today are Megan Flynn. Megan is the Executive Director of Pollination, which specialises in providing climate change advisory and investment advice. And Megan is also a board member of Sustainability Victoria and the Carbon Market Institute. We also have Rebecca McGrath on the panel. Rebecca is currently the chair of Oz Minerals, and she is professional company director. She's sat on numerous boards over the last few years, and she has also worked in the oil industry in an executive capacity, both in Australia and overseas, for a number of years previously. And she was Chief Financial Officer and a member of BP's Executive Management Board for Australia and New Zealand. And last but not least, joining us from Singapore is Ernest Lim. And Ernest is an Associate Professor at the National University of Singapore and an old friend and colleague. He is one of the most prolific academics that I know, and he has a new book out with Cambridge University Press entitled Sustainability and Corporate Mechanisms in Asia. So I know we have some people from England joining us today. Welcome, good morning to all of you. And I hope there are some people from Cambridge because I know Rebecca and Noel are both graduates of Cambridge University. So we're going to get underway at this point. And the first issue that I was going to raise was with Noel Hutley. Welcome, Noel, who is just joining us from Sydney. Noel, in 2015, wrote a profile memorandum on climate change and directors' duties. He co-wrote it with Sebastian Hartford Davis, and they also published an update in 2019. Now, that memorandum got a lot of attention from the business community, and it was commissioned by the Centre for Policy Development. And interestingly, I know that my dean, Professor Brian Horrigan, was instrumental in having Noel and Sebastian write that memorandum on behalf of the Centre for Policy Development. So that was a real wake-up call, that memorandum, for both company directors and corporate lawyers. And I know that many of them were really quite taken aback by your findings in that memorandum, Noel. And I just wondered, could you kick us off by taking us through the analysis that you use to suggest that Australian company directors could indeed be at risk for breach of directors' duties if they fail to consider climate change issues in making decisions?
Thank you. Thank you. Thank you, Jenny. Yes, as Jenny's indicated, we were asked to actually address this question for the purposes of a business seminar on this issue. And in many ways, once one looked at the problem, it was sort of hard to avoid a conclusion that directors were concerned or necessarily concerned with these issues. One starts with the assumption that climate change risk, that is, as I understand it, the risk of rapid alterations in the climate brought about by human activity is real, and over what might be admitted to be uncertain timeframes, it's going to lead to, or could well lead to, significant changes in our living conditions at the broadest levels. Those circumstances, obviously, by the time we were asked, were matters of intense concern at a political level. And in Australia, particularly, there were, as it were, what you might call factional divides between politicians as to how this should be treated. Now, from the point of view of a corporation, if one starts from the premise that the board and each member of them owes various duties to the companies, particularly those set out in section 180 of the Act, which we used as the focus of our opinion, that is, in effect, the duty of care and diligence, which I'll take it you're all familiar with. And one took as a premise, which I've indicated, that there were significant risks for this planet. That seemed to entail significant risk for companies who had assets or were contemplating buying assets or entering into ventures, or in just about each and every aspect of their business. It's become particularly important with the ever-increasing obligations of companies to make disclosures to the marketplace and to others about their particular financial position and the like. It was really, in effect, those what seemed to us to be pretty obvious circumstances which led inexorably to a conclusion that boards of companies, depending, of course, upon the nature of their businesses, would confront problems with respect to assets and ventures of a continuing variety as what to do with the risk of these changes. And shortly put, that was, and I don't know if you'd describe it as a syllogism, but the broad range of reasoning which led to our opinion. That's really it.
So why do you think so many people were taken aback by your findings? Because I know you think that it was really quite obvious, but I do know that there are lawyers who, you know, suggest that they don't agree with it. So why do you think that there were people who were so taken aback by it?
I suspect, and I can't speak for the rest of the world by any means, but in Australia, there was, to a degree, a perception that this was a political problem rather than just a day-to-day concern of organisations confronting the investment and other decisions. And I suspect it was more a delusion of lawyers than it was of the women and men who were confronting major financial decisions for large corporations, who had probably twigged to the problem a long time before lawyers had, which is, as a matter of history, not an unusual circumstance.
Not the first or last delusion of lawyers, indeed.
But that's just a guess on my part.
Yeah. Can I just switch to Ernest and ask, you know, you've just written a book on these issues and how they affect, you know, Asia. How big an issue is this in Asia, Ernest, and to what degree do some of the jurisdictions in East Asia, where you're based at National University of Singapore, you know, how likely do they think that there can be liability for company directors for failure to take into account climate change issues?
Yeah, thank you very much, Jennifer, and thank you very much, Noel. Now, so as what Jennifer mentioned, I wrote a book in which I discuss how 6 corporate mechanisms can be used to promote sustainability in 4 common law jurisdictions in Asia, namely Singapore, Hong Kong, Malaysia, and India. So I examined, you know, ESG reporting, board gender diversity, constituency directors, stewardship codes, directors' duty to act in the best interest of the company, and imposing liability on shareholders. Now, with specific reference to Jennifer's question, let me start off first with India. So very interestingly, under Indian company law, directors are required to act in the best interests of the company, the environment, the community, the employees, and the shareholders. So environment is specifically included within the Companies Act of India. This is significant. So not only directors have to consider climate risk, they have to give effect to climate change considerations. But the difficulty is this: shareholders retain the power to appoint and dismiss directors. Shareholders are generally the only constituencies to have the power to bring derivative actions. Should the interests of the environment, should climate change considerations conflict with shareholder interests or shareholder preferences, how should the board of directors decide? Whose interests should the board of directors prioritize? Generally speaking, there should not be a conflict because attending to climate change considerations, taking into account climate risk, has a direct correlation with a company's financial sustainability and financial condition. But there could be certain situations in which that taking into account climate change considerations, such as, you know, taking certain concrete actions to reduce carbon emissions, will reduce short-term profitability, but there could be evidence of long-term profit generation. In this situation, should directors sacrifice short-term profitability for long-term profit maximization, long-term value creation? It is not clear to me that under Indian law, whether the directors could do so. In other words, when both sets of interests conflict, whose interests should be prioritized? This is under Indian law. Now, when it comes to Singapore, Hong Kong, and Malaysia, directors are not prohibited from taking into account climate change considerations. They are permitted to the extent that it ties in with corporate interests, because we all know that directors have a duty to act in the best interests of the company. To the extent that these directors can make the argument that having a considered view on climate risk is directly correlated with share price, is directly correlated with the long-term profitability of the company, I would even make the argument that directors are required to take into account climate change considerations. But
well, that was certainly Noel's finding in the memorandum. Can I think to you, Rebecca, because these are issues that, you know, as a company director, and I guess Megan too, you know, in advising boards, because, you know, you're advising them on these issues all the time. How do you deal with this tension between, you know, shareholder interests and stakeholder interests, because it's something that's becoming more and more important internationally. I think, as Ernest is pointing out, you know, how do you go about that, you know, explaining that tension or navigating it? Rebecca, do you want to go first, and then I'll flip to Megan afterwards?
Sure, Jennifer, and hi everyone. Thank you for the invitation, Jennifer, to participate today. I'm going to give an example of the company which I chair, which is the company called Oz Minerals. And we are an ASX 100 public company, and we produce copper and some gold. And we mine in Australia, in South Australia, but also in Brazil. This is something that we have done a lot of thinking about in particularly the last couple of years. And while the company and the board particularly, which I represent, acknowledge very much the responsibility to operate in the interests of the company, the way we see that, and we express that in our strategy, is that we see the strategy through what we call, or reinforced by, 5 pillars. And everything that we do in terms of strategy, we test against these 5 pillars. And the 5 pillars, and I've often said, including at annual general meetings, have equal importance. And therefore, this is part of the investment proposition. If you invest in the company, that you recognise, and I suppose that you support, because otherwise you would invest somewhere else. And those 5 pillars are held equally, in equal importance, are community, employees, suppliers, shareholders, and government. And you might say, well, where does environment and climate change feature there? Well, we see very clearly that that is predominantly through the community pillar, because how we operate in relation to the changing climate very much is of a concern and in the interests of community. And I say that in terms of the communities where we operate physically, but also the wider community in Australia and overseas. But I would say to you also that it links to employees, and in a modern company, employees have a very significant interest in matters related to climate change, whichever sector they work in. I think you would find, and maybe for some people participating, you may be surprised at the amount of interest and passion that is related to climate change in companies to do with the resource sector. It relates to suppliers. It also relates very much to government and the policies and regulations relating to climate emissions, etc. But again, but also shareholders. And we'll maybe talk later about that, but the number of shareholders, particularly fund managers, particularly, I'd say in Australia, but I'd say predominantly in Europe, who are quite challenging and very interested. And I think the level of their interest and their challenge and the information they're seeking is elevating each year around climate change, the company's position, the company's statement, the company's acknowledgement of climate change, and then the risk mitigation and the steps that it's taking to address climate change. So I think that 5-pillar example hopefully gives you a sense of how in a mining company we are responding and thinking about climate change for all our stakeholders in the interest of the company.
Thanks, Rebecca. And Megan, yeah, from your perspective, what's the trajectory that you have seen in terms of companies that are seeking your advice at Pollination? You know, are they companies in the energy sector, or are they all sorts of companies? And, you know, how have you seen it change, say, over the last 5 years?
It certainly has. Thanks, Jennifer, and nice to see everybody. It certainly has changed significantly over the last couple of years, and Noel's legal opinion was a kind of a stake in the ground and a wake-up call for a number of directors. But going back to what Noel said, I mean, his legal opinion was making the point that it is fundamental for every good business to manage and communicate its risks and opportunities. And all organisations are obligated to disclose material risk to their companies, and climate change is just one of those material risks. So it's not a new thing And so, but I think what we have been seeing over the last, let's say, 5 years, is that a greater awareness of climate change as an integrated component of risk management within an organisation, better data for organisations in order to evaluate climate change as a risk, and we are actually seeing climate change as a risk that is affecting companies today. So that's both through things like the bushfires that we all felt over the Christmas period, which horrifically feels like a distant memory now, but you know, is something still that organisations are working through. But also governments like Victoria and around the world are adopting policies in response to climate change as an issue, which is something that organisations are needing to respond to more quickly and more directly. Organisations are seeing direct damage to assets and indirect impacts from supply chain disruption, and regulatory measures being put in place around the world requiring them to specifically address and disclose climate change as a risk to the business.
Yeah. Thanks, Megan. We've got a question that's come in. It's for you, Ernest, and it's from Sohan Pujar. Sohan, thanks so much for your question. He says, hi, all esteemed speakers. Hello, Pujar, Sohan. This question has there been a case under India's law system where there has been a conflict between a company's impact on long-term sustainability and shareholders' short-term goals or objectives? I'll let you answer that, Ernest, but my initial thinking would be it takes so long for any case to get through the Indian system that it would be a miracle if there has been such a case, but I'll pass it to you.
Yes, Jennifer, your intuition is correct. In response to the question, as far as I'm aware, there has not been such a case. But scholars and policymakers have been wrestling with the question of what if there's a conflict, and what if trade-offs are required? You know, it may not be required in all circumstances, but in certain difficult situations, if trade-offs are required, if there's a conflict, whose interests should be prioritized? Because the Indian Companies Act effectively requires directors to balance a multitude of considerations.
India is also interesting because, you know, one of the things that I think Megan was saying is that there's been a shift from seeing climate change as just part of corporate social responsibility to really, you know, having a life of its own in recent years. And Indian corporate law, of course, requires companies, or it might be public companies, is it, Ernest, you know, to donate a certain percentage of their profits each year to CSR issues, which is quite unusual in common law jurisdictions.
Yes, that's right, Jennifer. You are absolutely correct. They have to donate 2% of their profits. Companies of certain size are required to do that. They are required to constitute a CSR committee, to have a CSR policy, and to devote 2% of their profits to executing this policy.
Yeah. Just going back to Rebecca's point about, you know, the 5 pillars and them being equal. One of the things that interested academics in this area in 2019, the US Business Roundtable, which had always been viewed as a quintessentially, you know, profitability first and foremost and totally shareholder centered, came out and said, we got it wrong all along. We are now going to take into account, we're now taking a stakeholder approach, and our whole approach is to basically look at all the stakeholders. And it's interesting, there was such a division in terms of how people accepted that statement. Some people said how marvelous, at last American, you know, business community has accepted that these issues are really critical and important. And other people were totally skeptical and said, you know, this is purely so that the business roundtable in the US can have managerialism where there is very little accountability. I mean, have you come across any of those sort of reactions, Rebecca, in companies that you've been in?
Yes, Jennifer, I have, and I think that's a really interesting example. And speaking to people that, work as directors, I think there was, I think, I would say, general positive response, but certainly some skepticism. And I would say to you that there are some very well-known, high-profile company directors in Australia who would say that it doesn't need to be explicitly brought out in that way, because the role, the responsibility to the company in a modern society, in a modern environment, requires you to act responsibly in terms of the environment, in terms of ethics, your supply chain, your employees, to be a modern employer, to have policies that respect individuals and their rights, et cetera, et cetera. And so they would say to you, it's going too far. It should sit with the responsibility of the company and the success of the company. I would say I don't have that degree of concern. I understand their position, but I think being explicit about a responsibility going beyond the company is not necessarily a danger to the director, because I think it's already there. And as Noel introduced the topic, it is one of those risks that a company director should foresee. It is a known risk, and it is like, as Megan said earlier, it is part of the risk management approach that a professional company director should insist upon and should interrogate and should be well across in relation to the company, where they operate. So there's a perspective and a few others along the way, but I think it's there, whether it's explicit, it's certainly implicit.
Yeah, and I think that's consistent with an approach that ASIC has taken in one of its discussion papers on compliance issues, that a lot of these so-called non-financial risks are actually financial risks at the end of the day.
You're absolutely right.
Yeah.
Most of the non-financial risks that have been surfaced recently through particularly the financial services sector ultimately become financial risks, and the ultimate test being the share price. And I think we can see that fairly direct correlation.
Yeah. Now, one of the things we tend to look at these issues and think, oh, they're very of the moment, they're the hot issue at the moment. But when we were having a brief get together yesterday by Zoom, I know, Noel, you said, well, you don't buy that at all. You think that, deeply in history, these issues have always been there. So I wondered if you could just tell us something about your views on that.
Well, commerce has had to address the risk constituted by the variability of the climate, as immediately reflected from time to time in the weather from the earliest times. Marine insurance policies appear to have evolved in the early 14th century in Italy, coming out of essentially marine financing instruments. And their central concern was the distribution of risks in relation to what were called perils of the sea, which in turn had as their what might be called central concern the weather and its variability over space and time. In fact, marine insurance litigation seems to have been quite common by the mid-16th century in England. Now, as early as 1830, in relation to building contracts, it was held in England that bad weather was no excuse for the non-performance of a contract, as the variability of the climate was the circumstances that parties had to be taken to have known. And much ingenuity has been devoted in that field to spreading the risk in relation to those things. Now, someone has remarked that weather is to climate as mood is to personality. And the law has had to deal with the risk of mood swings for many centuries and will continue to do so even if climate change renders them more alarming. As Megan observed, modern information and modern technology has increasingly alarmed armed our society with the means to anticipate changes in what might be called the personality. The legal consequences for companies of that development and the magnitude of likely change is what throws up the arrays of problems we are discussing, except perhaps for the, as it were, aspect which scientific developments have allowed us to take advantage of. The problems are no different to the problems that commerce is confronted for many centuries.
Thanks. We're getting lots of questions coming in. Could I ask those of you sending questions, please identify yourself. I have a specific question for you, Noel. What do you think of the potential future risk of climate change litigation against companies and their directors?
It seems to me that much will depend in particular countries upon the array of legislative and other obligations upon companies with respect, particularly as has been observed by my colleagues, about disclosure, and also the legal regimes which exist in those countries to afford opportunities for third persons, which include shareholders, people dealing with the companies and the like, and also regulatory organisations, to seek to visit liabilities of one variety or another upon the company. Now, in Australia, we have a large array of obligations of disclosure, particularly for listed companies, and Rebecca, no doubt, could speak as to the real nature of that, the content of those obligations. But essentially, broadly speaking, companies have an obligation to disclose material price-sensitive information to the marketplace. Now, in this country, a significant litigation industry by way of class actions has developed in relation to alleged failures of companies to adhere to their obligations as to disclosure. Now, if I was, as it were, of a betting inclination, I think the first large and expensive climate change litigation in this country will be some overstatement by a company as to its climate change preparedness, or an understatement as to its risks with respect to particular assets of a significant variety. It may be of a mining variety. Some people have referred to risks brought about by climate change of stranding of assets such as coal that may well become it's a complex issue, and I'm not suggesting it'll necessarily occur, but it's certainly a risk. But boards of directors which don't keep those issues constantly under consideration, and if a bad result falls in, I think they will find themselves on the back end of a class action seeking to recover from the company and or the directors, depending upon the solvency of the company, for the shareholders' loss brought about by changes in the price of their securities. That's just one example, but you can multiply it across a whole series of circumstances. Regulatory actions for pecuniary penalties for non-disclosures or misleading conduct are becoming a regular feature in this country, and I can't see any reason why risks associated with the climate might not produce such litigation. But they're just some examples. One could descend to particular individual commercial transactions. In this country, we have, as it were, overriding statutory norms against engaging in misleading and deceptive conduct, which, broadly speaking, prevents a company, even if acting innocently, from making a misleading statement in trade and commerce. Now, in many countries, that's an anathema, but any person in Australia who's familiar with that particular statutory norm never underestimates its capacity to expand exponentially from time to time and give rise to litigation. It has, since it was brought into effect in the latter part of last century. But that's, so I think there is a large scope for litigation in relation to climate change risks.
Megan, yeah.
Yeah, just going to add that one of the most significant developments in this space over the last couple of years has been the emergence of a standard or best practice for companies to, or for directors to utilise to meet their obligations of disclosure. And that was the Task Force for Climate Related Financial Disclosures, or TCFD, because we all need more acronyms in this space. That was recommendations developed by the International Financial Security Board to set out a framework for companies to apply to enable them to integrate the identification, assessment, management and disclosure of climate related risk. And all companies in Australia should be thinking very quickly about how they utilise that framework within their organisations. Including because it is being moved to be regulated as a minimum standard in different places around the world. So New Zealand at the moment, so any dual listed company in Australia, the ASX and the NZX should be moving very quickly. The New Zealand government had a discussion paper out in October last year looking to implement a regulatory requirement for companies to disclose climate risk in accordance with the TCFD. You know, just recently, actually the last couple of months in Canada, if an organisation over a certain size, if they were to be eligible to receive COVID relief, they needed to commit to disclosing climate risk in accordance with the TCFD. So this standard is being moved to be regulated as a minimum standard around the world.
Could I just add one thing, Jenny?
Sure.
Until relatively recently, I was a bit sceptical as to whether there would be a great explosion of this litigation, but purely on anecdotal basis, I'm seeing a lot of interest being expressed throughout the legal community in undertaking such litigation as at today, which has surprised me, I must confess. So I kind of, at one stage, I was a bit sceptical that this might take quite a while to develop and how it would develop, but it seems to be increasing virtually day by day.
Well, I think in the broader environmental space too, we're seeing more cases. There's a couple of quite unusual cases in the US of pollution of rivers where directors, you know, are potentially going to be liable for that, whereas generally under the duty of care, they would say we didn't know what was going on and they would get off. And then, you know, last year there was a case in the UK, Vedanta and Lungau, which held that a UK parent company could be held liable for environmental damage of its subsidiary in Zambia. So, you know, I think these sort of transnational type issues are going to come up. Ernest, do you have anything to say on that issue of, you know, either director liability or corporate liability in Asia? Because, you know, you certainly have a fair bit of environmental damage in parts of Asia.
Yeah, so I'd like to address the point about disclosure of climate risk. So in Singapore, Hong Kong, Malaysia, and India, the disclosure of climate risk is essentially covered by stock exchange regulations pertaining to ESG reporting. So based on an empirical analysis of the disclosure of environmental disclosures provided by companies, as well as disclosures related to governance, I found that those disclosures to be quite superficial and of a boilerplate nature. And one problem that I see with the climate change disclosures provided by the listed companies in these 4 jurisdictions is that they are, the regulators do not subject such disclosures to any sort of audit requirements, and there are no penalties or sanctions, whatever, that have been imposed for, for very cursory disclosures, or even failure to provide a disclosure. Because, for example, in Singapore and Hong Kong, they adopt the comply and explain mechanism. If you cannot comply with the rules, you just have to explain. So I think one thing going forward to further enhance the quality and the quantity of environmental disclosures provided by listed company is perhaps stock exchange could either provide some oversight of such disclosures instead of leaving it exclusively to the shareholders or stakeholders to monitor the quality of such disclosures.
Thanks, Ernest. I mean, this discussion about disclosure really takes me back to the last of these law and business seminars that we had, where the commentator at that one, it was on corporate codes, governance codes around the world. And Priscilla Bryans from Herbert Smith Freehills, she raised the point that the disclosure requirements under the Corporations Act are actually pretty narrow in Australia. But when you get to the ASX corporate governance principles, which apply on this comply or explain basis, they're, since 2019, with the 4th edition of that code, very broad ranging and open-ended in terms of environmental and social risks. And so, I'm interested from, Megan and Rebecca's perspective of, are companies going down that track or just forging their own path in making sure that their disclosures, comply with higher level international standards? Who's going to start?
Jennifer,
Rebecca, yeah.
Jennifer, I would say really interesting, important points made by Noel about the Australian disclosure obligations. And for those of you who are attending this session from overseas, you will find that disclosure, the obligations on directors around disclosure in Australia, it's quite a high bar. And so it may be different to the disclosure obligations, say, if you're joining from the US or parts of Asia. So I would say to you that two things that boards of public companies are doing, which really assist in making sure that they have thought through disclosure around climate change. And there's lots of others, but two of them, which are particularly useful, are through the annual report. There is a requirement to produce what's called an operating and financial review, or referred to as the OFR, because we love acronyms. In the OFR, a company is required to set out the key risks that the company is facing. And this is at a corporate level. And I would say to you that it would be very surprising if any company that's industrial in nature or have operations, particularly industrial companies or heavy asset companies, do not have or should not consider having one of the key strategic risks for their company being climate change. And by doing that, it sets out what the company believes the risks to the company are and the mitigations that are being taken or being put in place. So that's one thing. And the other thing, which I think really is the critical element, is what was raised by Megan, which is the TCFD framework, the Task Force for Climate-Related Financial Disclosure. I'm involved in 4 companies. 3 of them are public companies. One's unlisted, but a large property company. And all of those companies have applied the framework. We're at different level of maturity in doing that. But by setting that out as a commitment to the shareholders and stakeholders and publishing that in the annual report and the progress against that, and for those of you who are not familiar with it, sets out requirements like governance, standards, metrics, etc. So as you mature by applying through this process of applying the framework, you set out all of those elements about how you're thinking about climate change and how you're taking action in relation to climate change. So those are 2, I would say, very important tests for a company to say, how is our disclosure? Have we talked about climate as a strategic risk in our annual report, as we are required to set out the risks to the company? And have we applied, or are we looking into applying the framework of the TCFD and setting out the work we've done for stakeholders in our annual report? Thank you.
Thanks, Rebecca. Just before I go to Megan, we've got a number of questions about disclosure. And I just thought I might at least give you one of them before you speak, Megan. We've got a question from Aaron Goldsworthy. What sort of climate disclosure are we seeing from corporations with rural and regional based operations, e.g. agricultural, forestry, tourism, where there is arguably a greater risk of bushfire impact due to climate change? And Aaron's a senior consultant with ASSPL. So,
okay.
Yeah.
I'll make a comment and maybe hand it to Megan. Look, I think when you go through the framework, you identify, and you may well require some help. And so firms like Megan's this is not a marketing opportunity, but in most cases, my experience, we have used a third-party advisor to make sure we are fully challenging ourselves. You end up looking at the portfolio of the company, but also where it operates and the sorts of risks it is likely to experience. So exposure to bushfire intensity or frequency would be one, depending on, again, if you're as the participant has asked about rural areas. I would say also for one of the property companies I'm involved in, the increasing frequency intensity of rainfall in the Sydney metropolitan area, with things like hail damage, cyclonic level winds damaging property. So that creates, that's surfacing a risk. Then you have the issue of insurance, and the financial impact of that. Not only is the damage, but the insurance is going.
What happened? We lost Rebecca.
Come out when you go through this process.
Great.
So they're the sorts of things that come through when you go through this process.
Thanks, Rebecca. So Megan, over to you.
Yeah, it's a very good question. The utilisation of the TCFD framework provides all organisations a place to start in terms of going through the different components of assessing and managing climate-related risk within an organisation. And Rebecca mentioned a couple of those aspects. There are 4 main pillars of TCFD: governance, strategy, risk management, and targets and metrics. One of the substantive pieces of work within the TCFD application is what's called scenario analysis. So that scenario analysis requires an organisation to think about future climate projections and the resilience of their business model under those different climate scenarios. And that considers climate risk with respect to both the physical attributes of it and the transition-related attributes of it. And when we talk about transition-related climate risks, we're referring to both the regulatory implications, like carbon pricing and the impacts that climate regulation has on organisations, and then also shifting market dynamics that are a product of a changing climate world going forward. Specifically to the point around the implications for agricultural or organisations with operations in rural communities in Australia, there are quite acute effects, climate effects, that organisations with that exposure is likely to be presented with going forward. And it does require detailed thinking and specific understanding and data input into the analysis that does look at the specific locations and the physical impacts within those specific locations. And that is, this is another excellent trend of the last couple of years, is the emergence of data and publicly available information that can help companies inform their thinking with respect to their exposure to these risks.
I've got another question relating to disclosure from my colleague Steve Carabas at Monash Law School. He says there's a difference between an obligation to disclose climate change risks and an obligation on directors to ensure corporations they manage do not act in a way to exacerbate those risks. Is this merely a matter of disclosure, or should it be something more? So I guess yes, the difference between companies creating risks as opposed to not managing the business in the light of risks. Anybody got a comment on that? Raise your hand if you do. Sure, Megan, you do. I can tell. Oh, Noel does. Noel, and then Rebecca, and then Megan.
Should I go first, or Rebecca?
Yeah, you go first, Noel.
The difficulty is with the concept of creating a risk. Firstly, in a modern world where politically it would appear that there's an ever-increasing possibility of governments changing the legislative environment in which one acts, the creation of risks, which might be said to be relatively often an externality, and therefore something that other people have to deal with than yourself, assuming they're not currently regulated, one would have thought carries with it a significant, as it were, legislative risk, because this area is dynamic in that way. One can see, for example, in decisions of our Land and Environment Court, that concerns with respect to climate change are starting to, as it were, filter into approvals of development. So in effect, if you're proposing to create a risk in the development, that may have an effect upon your ability to pursue it. So that's all I wish to say about that. So I'm not sure that there is a clear distinction between the two concepts by any means.
Rebecca?
A really interesting question. I was just reflecting on the creation of risk, and I think in some of the materials that many of the listeners today would be aware of, referring to a recent proposal for a coal mine in New South Wales that was not approved on the basis of the emissions that would be related to it that would be created in the future. And I think that's that certainly has created a lot of controversy, and I believe it's being appealed. But and again, something controversial, but I think when you look at voices in the government, in the current government of Australia, saying we should build coal-fired power stations, well, that's certainly creating a risk. And so I think interesting challenge we focus a lot on the obligations of directors and companies, but what about where government's creating risk? So can there be a situation in the future where there's a class action by the community about risk creation around emissions and climate change intensity to do with things like power stations? So very interesting, I'd say, emerging issue when it comes to new risk creating activities.
Megan?
I'll just add to what Rebecca's just said, saying that perhaps there should be an obligation on governments to be reporting against a TCFD framework as well, both at the state and federal level, and that would create somewhat of a level playing field in terms of the requirement on decision makers to be assessing climate-related risk and disclosing it to interested and invested stakeholders.
And Ernest, I know in your book you were looking at a whole range of mechanisms for dealing with issues on climate change. Did you come out, with the view that disclosure could be an effective mechanism, or is it all hopeless?
No, I think that I think one key lesson from the book is that we should not think in terms of silos. It has to be, the mechanisms have to be well integrated. So, in terms of directors' duties, in terms of ESG reporting, in terms of imposing liabilities on shareholders. So with regards to your question specifically, in order for disclosure to be effective, there has to be deterrence. And I think there has to be sanctions of some sort, and has to be some disincentives of some sort. So what I'm seeing now is that it is possible for listed companies to get away with poor climate change disclosures in certain jurisdictions in Asia. And given the fact that the stock exchange has been quite laissez-faire with regards to the ESG reporting, in order to make sure that disclosures do have a bite and that companies are held appropriately accountable, I am suggesting that there could be some sort of public criticisms, sanctions, perhaps requiring the companies to subject the disclosures to audit, given the fact that a significant percentage of the major listed companies have actually enlisted third-party auditing companies to review their disclosures and to issue opinions stipulating that the disclosures meet certain standards.
Thanks, Ernest. I have a question here from my dean, who's in our audience. Hello, Brian Horrigan. Brian's got a question for Noel, but I suspect it actually plays into what Rebecca and Megan have just been discussing as well. And the question is directed to Noel. Do you think that your two published legal opinions on this topic have potential crossover relevance in other areas of law beyond the Corporations Act, e.g. the law of directors' duties for statutory corporations and state-owned enterprises, risks to be managed in gaining project and planning approvals from planning environmental authorities, etc.? So I think that really dovetails with what we've been discussing, no?
Insofar as liabilities of such bodies, insofar as they're statutory, they've usually got fairly high degree of protection. They're usually also not engaging on the whole in trade or commerce, and therefore not exposed to what are the usual overarching norms which impact upon them. As to the directors' liabilities to the organisations, state organisations aren't in the habit of suing their managers, in my experience, for kind of, I think, bureaucratic reasons besides anything else. But it certainly will impact upon a lot of other organisations, particularly trustees of superannuation trusts and the like, who are vast investors, are equally exposed to these obligations. But as to statutory organisations, one really has to look at the particular statutory regime to identify the position of the individual director.
Thanks, Noel. Rebecca, Megan or Ernest, any comments on that question? Nope. We'll move on then. We've got a couple of questions on the ASX corporate governance principles. Philip Cornwall from Allens, he has said, in the light of this discussion about the broad scope of directors' duties, is it not odd that the ASX was widely berated for having the temerity to suggest in its draft governance guidance that directors should be alive to the need of companies to preserve their, quote, social licence, such that the phrase was deleted from the final guidance? Well, for those of you who are overseas, we got a redraft of the ASX corporate governance principles last year in early 2019. In the draft, there was this reference to public listed companies in Australia having a social licence to operate, and the business community reacted strongly to that. Rebecca, can I pass that to you?
I'm sure, Jennifer. Yeah, I'm aware that a lot of people did react to that. I personally didn't have a great concern about it. I think though, so so you react from it from a perspective of, well, that's not the role of the corporation. So I put that to one side because I think that is a sort of fairly outdated view, but it still exists. I think it's this sort of concept of social license. What does that mean? And so you can refer to something, but then you really need to explain what that is. And then you get into a sort of very detailed description and very particular requirements, which I suspect they were trying to avoid because that becomes a bit of a minefield. I would probably refer back to my previous comments that if you operate in the interests of the company in a modern environment and with all of sort of the factors you have to take into account about how you treat your customers, how you work in the community, the impact you have on the environment, and actually getting a license to operate. If you're a mining company, you actually have to get a license to operate. And we see globally some terrible, catastrophic examples of where that license has been abused, or in the first case, in the first instance, was not even required in certain countries. So I acknowledge and I'm aligned with the concept, but I think the challenge with that wording was, what does that mean? And then, as I said, do you get into a very prescriptive model after that to define that? And I think that's where
my understanding is that the term originally came from the mining sector. Is that your understanding too?
I think it probably did. I don't know for a fact, but I think it's very likely. And it is very tangible, very real, and one of the biggest constraints to not just mining, but exploring. And to get a license without having a track record, a good track record in a lot of jurisdictions is becoming almost impossible. And even in, countries like the United States, where we might say, well, they have, particularly in recent, under the current regime, where there might be laxer environmental requirements, it's becoming incredibly difficult to mine in the United States in relation to Indigenous land, protected environmental areas, et cetera, So license to operate is an enormous barrier and risk to the mining industry.
Megan, did you have a comment on that point? No. I know that Elizabeth Johnston, who's the chair of the ASX Corporate Governance Committee, when the wording social license to operate was taken out, she said really it didn't make any difference because they just replaced it with words like the reputation of the corporation, which she said basically meant the same thing. So, what was the big deal about? Now we have another question here. I've got questions everywhere. Megan and Rebecca, do you think that the carbon pricing mechanism of 2012 to 2014 had any effect on carbon emissions in companies in the mining and financial sector? Anyone want to?
I'm happy to take that. I'm not quite sure it says why it says financial sector. I presume it means the risks that banks have taken on. Yeah, okay. Yeah. I would say absolutely yes. There was some emerging, there was a very early stage trend in the resource sector to use what I call a shadow carbon price. BP was doing that 15 plus to 20 years ago to test projects and how attractive a project would be with a carbon price attached to it as a future possibility. And so to answer the question, I would say a lot of companies started much more actively measuring their emissions. A lot of companies started taking a lot more action, which are, quite financially beneficial, to take action on abatement measures. And then a lot of companies started to think about or apply as a test or as a shadow carbon price to understand if a carbon price came in future years, would this $500 million, multiple billion-dollar project be as viable? So I would say all of those things have come and accelerated as a result of that period where the likelihood of a carbon price became quite tangible.
And I would agree with all of that. I think the utilisation of shadow carbon prices, while they were being used previous to that period, they certainly were implemented in a number of organisations beyond the resource sector during that period and have been maintained post. The other thing I think is a really excellent outcome of that policy period was off the back of following that was the emergence of the carbon farming industry. So along with the carbon price came a mechanism that whereby landholders and operators in the land sector could create carbon credits from different activities that either reduced or avoided emissions through practices in the way in which they manage land. And that can be done by either planting trees or preserving and restoring native vegetation, herd management practices, or utilising traditional Indigenous practices like savanna burning. And the emergence of that marketplace in Australia, I mean, it's world leading in terms of the methodologies and the governance around that market in Australia. So it was one of the success stories out of that policy period.
I guess one of the issues that some of these matters bring up was something we talked briefly about yesterday, and you raised it, Noel, simply how company directors navigate political instability and, you know, the danger, the risk that a change in government can result in a massive change in policy. And, you know, I suppose that's something you don't have to worry about quite so much, Ernest, in Singapore, but maybe in some of the jurisdictions that you looked at, this issue of, you know, political instability might have come up. How do company directors deal with that, you know, both in Australia, Rebecca, and in Asia, Ernest? Rebecca?
Yeah, thanks, Jennifer. Look, it certainly is an issue, but on a world scale, I think it's not as big an issue for Australia as some might like to make it. I think energy policy, though I should say, I think the lack of energy policy, and when I say that, I mean policy around emissions and renewables and setting a long-term position or transition for the country is a real obstacle. And I say that for the sort of high level emitting type sectors, so particularly the energy sector, but also the industrials. And, you know, we've heard a lot recently about how Australia has become so deficit in manufacturing. And I can tell you from first-hand experience as a former director of CSR who make building products and a current director of Incitec Pivot who make agricultural fertilizers and explosives, the lack of energy policy and certainty is causing plant closures. It's causing the companies to reduce its manufacturing footprint very materially, and a lot of jobs obviously are linked to that. And I say that not as a political statement, but as a statement of fact. So I think the lack of certainty, even if there was a policy that was, you know, seen as conservative or retrograde in terms of climate change, that the lack of policy certainty is a real issue. And I think now that jobs have become an issue in the COVID era, I think we're seeing, interestingly, a lot more attention to energy policy and the impact that it's having on the country, its economic impact, its jobs impact. And I hope that that also links to a much more strategic view about its climate impact. So that's
Rebecca, just before I let you go there, I've got a question that's come in for you, and I'm going to take you back to your 5 pillars. And the question is from Christy Dixon at Mark Lawyers, who asks, has your company considered enshrining the 5 pillars in your constitution? And would you consider that that would have any impact on your director's duties if you had the 5 policies in your constitution, as opposed to just a guidance?
Yeah, it's a really interesting question. I I can tell you that we haven't considered it, and that's just, it hasn't come up. It is felt very passionately by the board and the management. It's something we very much feel ownership over. And so it is quite an interesting consideration, because as board and management change over time, does that I think I presume the inference behind that is, does it get watered down or does it get dropped? And so I like the question, and I'll certainly give it some consideration. Constitutions, as we know, tend to be somewhat minimalistic for good reason in certain areas. So, but thank you for the question, and I understand the tone or the intent of that.
Yeah. Now, I want to turn to Ernest now, because we mentioned early on the role of institutional investors, and we've seen certainly some very striking comments by institutional investors. So Larry Fink from BlackRock has basically said that from now on they're going to be doing all their investment based on sustainability. They're not going to be investing in companies that have climate change risks. And one of the things that we have seen really proliferate around the world since the global financial crisis are so-called stewardship codes, shareholder stewardship codes. And Ernest, I know you would have discussed this in your book, because Asia has really adopted these stewardship codes coming out of the UK. Australia still doesn't have a national one. We have sort of individual institutions adopting them. Do you think that they can be valuable, Ernest? And, you know, after the Hayne Banking Royal Commission, we thought shareholders were the problem, but maybe there's the solution to the planet's problems. What do you think?
Yes, thank you, Jennifer, for this really important question. So Hong Kong, Singapore, and Malaysia have come up with stewardship codes that apply to institutional shareholders, namely asset managers and asset owners. In the case of India, there is no overarching stewardship code, but there are codes that are directed at certain classes of institutional shareholders, such as pension funds, insurance funds. Now, the question is whether stewardship code is effective, and I address that in my book. In order to answer this question, we need to understand the structure of ownership in many of the jurisdictions in Asia. So for the 4 jurisdictions that I cover in my book, Singapore, Malaysia, Hong Kong, India, these are concentrated ownership jurisdictions, namely controlling shareholders are the norm. Namely, you have government who is the owner of some of the most powerful and influential companies, and you have families who are the owners of some of the most powerful and influential companies. And institutional shareholders are the minority. They individually, they do not wield sufficient voting and control rights to be able to exert any, to make any significant changes to the company. Although collectively they are able to do so, there is the problem of free rider, and as well as apathy among a number of these institutional shareholders. So the short answer to your question, Jennifer, is that there's some sort of legal transplant misfit, because many of these jurisdictions transplanted the UK stewardship code model to their own jurisdiction, namely as a form of signaling of good corporate governance, as opposed to making any substantive changes in the behavior of institutional shareholders. So if we want to make significant changes, we need to ask ourselves, how can controlling shareholders be stewards, and what does that mean? Okay. Yeah. Because they are the ones that wield the significant powers in these 4 jurisdictions. This is the first point. The second point is this: the stewardship code is voluntary, non-binding, so it's really up to the institutional shareholders whether they want to sign up in these 4 jurisdictions. If they don't wish to sign up, there are no disincentives, no penalties. So that actually exacerbates the matter as well. So that's it.
Thanks, Ernest. It's true that in Asia, you know, empowering the shareholders, giving them stronger incentives to be involved, they've already got them because they're the controlling shareholders, either the state or the family members. In Australia, though, we do see institutional investors, I think, flexing their muscles more. It was reported a few days ago that First State Super, which has $130 billion in retirement savings, announced that it would exit any companies that derive more than 10% of their revenue from thermal coal mining. Can I ask the other speakers, what's your experience in Australia of well, both local institutional investors and also now that big US institutions like BlackRock are entering the market? What are you seeing? Megan first and then Rebecca.
Yes, I mean, it is a big and significant trend, and one that Australian organisations are very mindful of, is the role of institutional investors in advocating for disclosure and action with respect to climate change and other environmental issues. I mean, they themselves are recognising the risk that these issues present to their organisations, and therefore are agitating and advocating for companies with portfolios to be acting. And if not, then they're putting organisations on notice that they will take action. So I think the recent announcements, this is an emerging but very fast-paced trend, and companies should be heeding the warning.
Rebecca, have you had experience of this with the big institutions putting pressure?
I certainly have. I've certainly had it through the European institutions significantly in the property sector. In the mining sector, well, Oz Minerals is substantially held by BlackRock, so they are a very interested player when it comes to matters around ESG. And then I have a regular, periodic dialogue with ACSI, Australian Council of Superannuation Investors, and they have a very strong, determined view on a number of what matters related to ESG. Very much interested in progress and action on risk management around climate change, but also they recently did a big study on safety and trends in workplace safety. They're very interested and they ask me about diversity, gender diversity, ethnic diversity. So when I go as chairman to talk to ACSI, we speak, I would say, predominantly about matters around ESG, and in a secondary fashion in terms of time allocation about matters to do with performance, which they see through all our disclosure anyway.
Well, talking about time allocation, our time has come to an end. Well, I don't have to tell you how wonderful it is. I've got all these questions and comments coming in saying, please thank the speakers. It's been amazing. So thank you to all the speakers, to Noel, to Megan, to Ernest and to Rebecca. It's been wonderful to have you in this roundtable. Thank you for giving up your time. And I'd also particularly like to thank my colleagues Janice Hugo and Ellie Mitchell in our events team, and also the wonderful Laylee Greenwood and her team from the Institute for Better Governance and Policy for tweeting live throughout this. And thank you for everyone in the audience, both in Australia and internationally, who've joined us for this discussion. We hope to see you at our next event, which is 31st of August. It's a seminar on the role and effectiveness of ASIC and the SEC. And the speaker is Dr. Zara Kavame Eraglu, and we're going to have ASIC Commissioner Kathy Armour as commentator for that event. So we look forward to seeing you then. If you're not on our mailing list and you'd like to be, let us know. So have a great night, everyone, and thank you so much to all of you. Bye.